Hi, everyone. I think we're just getting ready to get started. It's nice to see such a full room today, and I know that we have several hundred people on the phone as well, so I don't want to keep them waiting. So thank you all for being here on such a hot day. I'm Cindy Lewin. I am the chair of the Nonprofit Organizations Practice Group here at Venable. We're a little different from others because instead of being part of the tax department, we have our own nonprofit organizations practice group. We're the largest in the country, and we certainly think one of the best. We've been getting awards lately, so it's not just us saying that. But anyway, we try to offer one-stop shopping, everything you would need, and we offer a lot of that in our nonprofit organizations group, but we also work with experts all over Venable, and we're so lucky to have two of them here today. Melissa, for those of you who come, Melissa's a regular speaker. I suck her in all the time because she's a wonderful speaker. She's a partner in our advertising group. In addition to native advertising and social media influencers, which she'll be talking about today, she also does sweepstakes, contests, promotions of all kinds, including with for-profit, so cause-related marketing. So we work with her all the time. We're very lucky to have Annie Lee, who's also a lawyer in our advertising group, but is based in New York. So it's great. Thank you so much for coming down today. Annie also does a lot of advertising, social media, but also direct mail marketing, email marketing, direct mail solicitations, things that no charity would ever think of doing. So it's great to have both of them with us here today. And I'm delighted that you all are here with us today. So with no further ado, let me turn it over to Melissa and Annie.
Thanks so much for the introduction. Before we get started, I just want to note that due to the high volume of webcast attendees, we'll be holding questions from our webcast attendees until after the event. In-person questions are welcome. Please use the mics on either side of the room. So thanks for having us. Today we're going to be talking about native advertising and social media influencer advertising. And these are two types of advertising that are becoming increasingly popular and are spreading like wildfire across the internet and are evolving. And in fact, even the types of influencers are coming from all different walks of life now. You've got your A-list celebrities like the Kardashian family. You've got makeup artists such as James Charles. You've got fashion bloggers such as Chriselle Lim. And some influencers aren't even human. You've got Grumpy Cat, who sadly passed away in May. May she rest in peace. And there's also Lil Miquela, who is a CGI influencer. She is entirely digital. But regardless of who an influencer is, they're all subject to the same guidelines and principles that are set forth by the Federal Trade Commission regarding preventing deceptive advertising. And that's what we're going to be talking about in detail today. So given the rise of native advertising and social media influencer advertising, more and more businesses and organizations are getting interested in delving into this space. And oftentimes they start off with the same preliminary questions. They'll ask, what is the big deal? You may have heard that when it comes to this type of advertising, it's very important that any kind of connection that the influencer has with the brand or the organization needs to be disclosed. Why does this matter so much? And why is this my problem? Isn't it the responsibility of the influencer to adhere to these guidelines? Why do I have to worry about this? And when do I have to disclose, and where do I have to disclose? Is it sufficient to place the disclosure in a hyperlink, for example, or an entirely separate web page? Or do I have to make my disclosure up front? And can it be underneath, beneath the fold, as we call it, where you have to press a button to expand a caption to see it? Or does it have to be above the fold? And how do I disclose? What do I need to say? Say, for example, a motorcycle company gives a free motorcycle to Keanu Reeves. And they do this in exchange for some social media exposure. He ends up posting a picture of himself on the motorcycle, and he posts it on his Instagram page with the hashtag thank you. Is that hashtag enough of a disclosure signifying the fact that he got that motorcycle for free? We're going to be talking about that more in detail later, but basically the answer is no, that's not sufficient. Is there anything else I need to worry about? For example, am I responsible for monitoring my influencers' posts to make sure that they're complying with applicable guidelines? Do I need to make sure that the claims that they're making about me are properly substantiated? And what are the government's expectations for compliance? Like I mentioned, the FTC has a set of guidelines that you need to follow when you are doing native advertising or you're engaging with social media influencers to promote your brand or your organization. And can I put anything in my agreements to protect myself? The answer is yes, and Melissa's going to be talking about that in more detail later on in the program.
One of the things, to step back, we had to delete a slide with some pictures of interesting of posts and the like, due to conflicts at the last minute. But you know, when we talk about native advertising and influencers, we are, of course, talking about everything from video reviews, which we'll discuss a little bit more in detail, to, you know, bloggers and, you know, we mentioned celebrities who are posting, talking about how much they love your charity, to articles about a charity that are maybe sponsored by, you know, you or a for-profit, and maybe don't talk about the fact that they've been paid for, as opposed to, you know, they look like they're a media placement or a media article. You know, when do you need to disclose that there may be something that, you know, they're sponsored or the like, there may be some compensation and that sort of thing. So we're going to spend more time really on the influencers or the like as opposed to the articles, but what we're really talking about is maybe something that looks like content that's independent in nature, but in fact is sponsored in some way.
Exactly. So the FTC requires that, again, material connections be disclosed. They have something called an endorsements and testimonials guide. And in that guide, they state, as is pictured here, when there exists a connection between the endorser and the seller of the advertised product that might materially affect the weight or credibility of the endorsement, in other words, the connection is not reasonably expected by the audience, such connection must be fully disclosed. And the FTC expanded upon that in its enforcement policy statement on deceptively formatted advertisements. It said that it'll find an advertisement deceptive if the ad misleads consumers as to its nature or source, including that a party other than the sponsoring advertiser is its source. So misleading representations of this kind are likely to affect consumers' decisions or conduct regarding the advertised product or the advertisement, including causing consumers to give greater credence to advertising claims or to interact with advertising content with which they otherwise would not have interacted. So all of this seems, you know, pretty common sense. But in today's day and age, where celebrities and social media influencers are able to engage directly with their followers on their social media platforms, and they really want to try to make their posts appear, you know, as organic and personal and spontaneous as possible, sometimes this line between an incentivized post and what's not incentivized could end up getting blurred. So who's enforcing these laws and these guidelines? Of course, at the federal level, you've got the Federal Trade Commission. At the state level, you've got state attorneys general. And there are, of course, the class action plaintiffs. For example, and Melissa will touch upon this more later on, there have been numerous class action lawsuits filed against the organizers and the promoters of the Fyre Festival. You may have heard about this festival. It was
the subject of documentaries on Hulu.
Exactly, right. It's a very interesting case. So it was marketed as a luxury music festival. Several high-profile celebrities were promoting it on social media, such as the Kardashian family and Hailey Baldwin and the like. But it really ended up being a debacle. So attendees ended up getting to the festival. They realized that there was no running water. There was a shortage of beds, so people were stealing beds from each other. There was a shortage of porta potties. And apparently the food was dismal. You may have seen a picture that went viral of a really sad-looking cheese sandwich in a styrofoam container. It's hardly what you would expect when you paid anywhere from $500 to $12,000 to attend this festival. And so many class action lawsuits have been filed, and they're alleging things from fraud to breach of contract to negligence and the like. So why is this my problem and why should I care? The FTC and the state AGs have jurisdiction over anyone who participates in the, quote, creation or dissemination of advertising. So essentially that could apply to advertisers, ad agencies, affiliate marketers, publishers, and even endorsers themselves. And the enforcement activity continues to be strong today, and the class action bar is getting more and more involved in this space too. So that means if you're a nonprofit organization and you're engaging with a social media influencer, for example, and the proper guidelines aren't being followed, then you're exposing yourself to risk there. So assuming we've convinced you that these guidelines are important and you need to know what they are and follow them, let's really drill down on what's actually required. You can pare them down to essentially 4 basic principles here. One is that social media has to play by the same rules as advertising and any other type of media. And the next principle is that one size does not necessarily fit all. So for example, if you have an employee who's writing a review about you or your services, the fact that that person is an employee needs to be disclosed. And obviously that disclosure is going to look different from, say, if you engage a social media influencer and enter into a sponsorship agreement for them to be promoting your brand. This same principle holds true depending on the format or the platform that you're using to promote your brand or your services. So for example, if you have a blogger who is engaged to talk about your brand or your services on their blog, they have a little bit more real estate to work with versus if they were tweeting out a tweet about you, where there's a very strict character limitation. If you can't say or do it yourself, people should not say or do it for you. So for example, if you can't say that your product cures cancer, your influencers can't say that also. And lastly, there's no hiding. So any connection with the brand by the person posting has to be disclosed. And you should really stop and think about, what does a post look like from your audience's point of view? If there is a relationship there that the audience member wouldn't reasonably expect, which is called a material connection, then that relationship needs to be disclosed. And the reason is because if you don't, it's deemed to be deceptive, because if they had known about that relationship, then that may have influenced their decision as to, for example, whether or not to purchase your product or engage with your brand or your organization. Examples of these type of material connections are the most obvious, if you pay somebody to promote you, if you give them free stuff, if you sponsor a review or a travel article, if the person is an employee of yours, or even if they're related to you. Those type of connections should be disclosed. So the FTC has investigated multiple instances of alleged breaches of this material connection disclosure not being followed. And one of these instances happened a few years ago when they were investigating the company Hyundai. It came to light that there were bloggers who had been given gift certificates in exchange for them including links about Hyundai in their videos or them commenting about Hyundai's forthcoming Super Bowl ads. And after investigating Hyundai, the FTC ultimately decided to close the investigation. And in its closing letter, this is what they stated: "The actions with which we are most concerned here were taken not by Hyundai employees, but by an individual who was working for a media firm hired to conduct the blogging campaign. Although advertisers are legally responsible for the actions of those working directly or indirectly for them, the actions at issue here were contrary both to Hyundai's established social media policy, which calls for bloggers to disclose the receipt of compensation, and to the policies of the media firm. Moreover, upon learning of the misconduct, the media firm promptly took action to address it." So there are 3 takeaways here based on this language. One is that you really should require a sponsorship disclosure policy of your endorsers, and that policy should comply with the law. The second takeaway is that you should make sure that those working with you or for you are aware of these policies. And the third is that you should monitor them to make sure that they're actually complying with these policies.
And this is really actually how the FTC started when it came to enforcing. It's the way the agency tends to work in terms of enforcing the law in a lot of new areas. When they started enforcing the law, this was obviously a new extension of the endorsements and testimonials rule. The FTC believes that when it comes to online, it's not necessarily a situation where kind of everybody knows, say, that a restaurant critic or a book critic may be getting a reviewer copy. That's not necessarily the same with blogs or social media where the public doesn't necessarily understand that bloggers may be compensated or may receive free stuff. So there's sort of a higher disclosure standard. When the FTC started enforcing in this area, they started with a series of closing letters to sort of let advertisers, marketers, et cetera, know this is how we think that the law should be interpreted. They actually started by adding some new examples to the endorsements and testimonials rules themselves. Then they started with these closing letters, like Hyundai or one against Ann Taylor Loft, where they said, oh, here's this promotion where you're giving gift cards to bloggers who attend a party. You should also be disclosing there, or you should be asking the bloggers to disclose there, and should have, have a policy on that. And then they went to enforcement, which we'll talk about in a little bit, where there was really, true. Here's, we're sending you the letter, we're doing a full investigation, and then we're entering into full settlements with you. So it's that sort of spinning out of how they're enforcing the law.
Yes. And to add on that, so one example of an investigation that didn't end so well with a brand was the investigation of Lord & Taylor. So the FTC investigated Lord & Taylor for its native advertising practices and also its social media influencer practices. Specifically, the FTC alleged that Lord & Taylor paid for native advertising like the ones you see on the screen. You'll see on the right-hand side, there's a seemingly objective article on Nylon.com. And there was also a Nylon Instagram post that they had made about one of their products. What they didn't disclose was the fact that they were actually paid promotions. I'm not sure if you can read the text that's up there, but neither of them disclosed the fact that they were paid by Lord & Taylor. The FTC also alleged that Lord & Taylor paid 50 fashion influencers to post pictures of themselves wearing the same paisley dress on their own Instagram pages. What they didn't disclose was the fact that the dresses were provided for free to these influencers, and the influencers were paid thousands of dollars for these endorsements. And according to the FTC, this connection would have been material to consumers because it could have influenced their decision as to whether or not to buy the dress. Lord & Taylor entered into a settlement agreement with the FTC. And under that settlement agreement, they're prohibited from falsely claiming that an endorser is an independent user or that a paid opinion or statement is independent. They have to disclose their material connections, and they also have to monitor their influencers to make sure that they're complying with all applicable policies.
That case, of course, involved both the article, so the native, and the influencer posts and the like. So It's sort of interesting on that level.
Now, where do you need to make these disclosures? In 2016, the FTC brought a matter against Warner Brothers, and this is a very interesting example of how not to disclose. Warner Brothers paid a number of video game influencers and gave them free copies of a game to post positive reviews about the game Shadow of Mordor. It's a game that's loosely based on the Lord of the Rings trilogy. They also told their influencers that to the extent there were any glitches or bugs in the game, that they should not disclose them. What ended up happening was that the vast majority of their influencers failed to disclose their material connection to Warner Brothers. Some of them did disclose the fact that they received free copies of the game, but they didn't disclose the fact that they were paid. And according to the FTC, that was deficient. Warner Brothers also told these influencers that the sponsorship disclosure should appear within the description box that appeared underneath their video review. But Warner Brothers also required them to include a bunch of other disclosures and statements in this same box. So effectively, what ended up happening was that a lot of these influencers placed the sponsorship disclosure, what we call beneath the fold. So it would only be visible if you clicked on the Show More button. This is an example of one such post. It was posted by the influencer I Am Wildcat. And if you take a look, above the Show More button, there are a couple of lines of text. But none of those lines of text disclose the fact that there was a material connection between this influencer and Warner Brothers. if you click the Show More button, then it unfurled several lines of text and statements.
Just a few.
Just a few. It was, everything from, click here for more information about me, click here for more information about the video game, click here for a free promo code for a discount for the game. And then way at the bottom there, he wrote, "This video is sponsored by Warner Brothers." And to make matters worse, right underneath that disclosure, he wrote, "No one reads this far into the description. What are you doing snooping around?" So this pretty much proved the FTC's point. Hardly anyone reads that far down. And this is exactly why you need to place your material connection disclosure up front so that, that people will actually see them. Warner Brothers ended up entering into a settlement agreement with the FTC. And under that agreement, they're required to educate their influencers about sponsorship disclosures, monitor them to make sure that they're complying with these policies, and also to the extent that they don't comply, Warner Brothers has to terminate them or withhold payment. In 2017, the FTC brought its first ever case against influencers directly in a case involving a gaming betting website called CSGO Lotto. And the influencers involved were these two gentlemen here. Their names are Trevor and Thomas. So what Trevor and Thomas did was they posted videos of themselves playing games and then talking about how much money they made on this gaming betting website, CSGO Lotto. They also talked about it on their social media platforms. So, for example, in the upper left-hand corner, that's from Trevor. Trevor wrote, "Made $13,000 in about 5 minutes on CSGO betting. Absolutely insane. Reactions here." And then a link to a video of his reactions to this insanity. Thomas wrote, "Bruh, I've won like $8,000 worth of CSGO skins today on CSGO Lotto. I cannot even believe it." What these bros failed to disclose was that they actually owned CSGO Lotto. And in addition to that, they paid several influencers thousands of dollars to promote CSGO Lotto on their social media platforms, but they didn't disclose that they were paid. And also, they prohibited these influencers from writing anything disparaging about the website. So not only did they violate the guideline that you need to disclose material connections, but they also violated the guideline that endorsements need to reflect the true and honest beliefs of the endorser, because essentially these influencers were forced to write positive reviews regardless of what they actually thought about the gaming website. In addition to bringing this case against CSGO Lotto, in that same year, in 2017, the FTC also sent out over 100 warning letters to prominent social media influencers, reminding them that they need to clearly and conspicuously disclose their relationships to brands when promoting or endorsing products through social media. And this was brought about because of petitions filed by Public Citizen and other organizations regarding influencer advertising on Instagram. And now I'm going to turn it over to Melissa to talk in more detail about how you need to disclose.
Thank you, Annie. These letters, actually, in the spring of 2017, marked sort of a turning point, and actually the case against our friends, the Bros, marked a turning point in the FTC's enforcement, in that previously the FTC had not pursued cases against individual influencers. They'd really just pursued cases against the marketers and the agencies, sort of following a deep pocket strategy, and not just deep pockets, but also sort of saying, gee, if we go after the marketers, if we go after the agencies, we can really pursue many at once, whereas the individual influencers, it's like shooting fish in a barrel. There are many little, small influencers. How do we get them all at once? There was a realization with the FTC that really there are a lot of influencers making a lot of money out there. And so perhaps we should be pursuing them as well. At this point, the FTC is sort of pursuing multiple avenues here, the marketers, the influencers, and the agencies. With those letters, though, to the individual influencers, they also started a strategy to sort of get some more definition, detail on how to disclose on specific platforms. With the .com disclosures, which was a document that the FTC first issued in 2002 and then updated in 2012. The agency had tried to give some detail on how to disclose generally in advertising on different platforms. But with these letters, they tried to explain what some of the expectations were in terms of disclosing on Instagram when it came to influencer disclosures. So when we're going to get into a little bit, oops, I'm going backwards. That's not good. A little bit about what to disclose, how to disclose on different platforms when you're talking about influencer campaigns. In terms of what to disclose, the standard is really that any material disclosure between an advertiser and an influencer needs to be disclosed. So obviously payment or any kind of free stuff, travel, or other thing of value. But when we're talking about other thing of value, it can be something of relatively small value or really almost any value according to the Federal Trade Commission. So they've even gone so far as to say that a sweepstakes entry, the offer of something that you can win, needs to be disclosed. Rewards points, really small values need to be disclosed, and you need to require people to disclose them when you're offering them. Also, we talked about employees need to disclose, or other business or family relationships, like an ownership value. That's interesting. Sure, I'm sorry, and I'll remember that hopefully in the future, but remind me. Should nonprofit members be disclosing?
And for example, and if what's up there, that member may or may not, and it may make a difference before or after it's back, given free registrations.
Certainly, if you're being given anything for free, then you should be disclosing. That's a clear one. And if you're a member, I would say that it's probably in your interest in any event to be disclosing. I don't know that it's been clearly addressed at this point, but it would probably be a good idea. And business, equity interests, family relationships, that sort of thing. So along those lines, I would think, extending that, the membership would be a good idea too.
And our stance is generally always, err on the side of safety. I mean, to Melissa's point, even things that you wouldn't think would matter, such as a sweepstakes entry, for example, in exchange for a review, the FTC has said, that's something that needs to be disclosed. And, this is something that you've probably all seen. If you go on Nordstrom, for example, if they're running a giveaway and if they say, if you write a review, you'll get a free entry into a sweepstakes, now there's an automatic disclosure that gets posted with each review. Mm-hmm. So it's definitely something that businesses and the like are becoming more and more aware of and they're complying with.
And certainly there are times when we'll call somebody at the FTC and ask the question, and it's always disclosed. And the other thing is, the other standard is, would the consumer expect it? If somebody's reading that review, would they want to know, this person has been paid, has received something for free? That would influence, how you reviewed the product, if you've received something or know you will receive something in return. We were just looking at something about somebody is being offered the chance to appear on TV, with their review, if they're writing the review. That may influence how you write the review. If you know that your review could be on TV, that has to be disclosed. So, in terms of the I just went backwards again. That's why
it's counterintuitive.
The one situation where you don't have to disclose, it really is. Maybe we should just turn it around. The one situation where you don't have to disclose is in the situation where there's mere product placement. That's a situation like we've shown here on American Idol, where they're drinking Cokes and the Cokes are just sitting on the desk. Or you know, the other question where it's come up is Selena Gomez, where she's just got a Coke in her hand and she's drinking it. It's a tough situation. The question is always, are you making a claim about a product? The FTC has said where you're just showing a picture and you're tagging different products, that can be a claim because you're showing that you're using these, you know, pieces of clothes and you're tagging them. That can be a claim. Whereas just having a Coke on the desk because you're drinking it isn't necessarily. So it can be a very fine line and something that's hard. You have to do some thinking about. But mere product placement in a TV show hasn't yet reached the point where it has to be disclosed.
But I do know that for TV shows and movies that Coca-Cola and Budweiser beer pay.
They do.
So where does that fall?
That is not at this time something that has to be disclosed. So, because there's no claim, it's just something that's being used in the movie. So, how do I disclose? Disclosures must be clear and unavoidable. The idea is that they must be prominently placed, they must be clear, conspicuous, and easy to read. So, through its cases, through FAQs, you can find FAQs on the FTC's website, ftc.gov. The FTC has sort of elucidated different principles for how things should be posted. The disclosure should be early in the post or the tweet. On Instagram, it needs to be, or anywhere, it needs to be before any break. So if you're reading something on your phone, it needs to be before that point where you have to hit more on the Instagram post. Above the fold, as we talked about on a video or a blog post. It can't be buried in a string of hashtags, so you might not see it. That's another important point. There can't be any abbreviations used. The FTC does not think that the consuming public can understand abbreviations. Things like hashtag SP or hashtag sweeps are a no-go. Another thing is that the different platforms have come up with sort of form disclosures now. The FTC has warned people not to rely just on those. So like Facebook has a form tag, Instagram does. The FTC does not at this time think that those are sufficient. They're very small and not necessarily clear and conspicuous. In video, on YouTube and Insta and the like, you have to disclose in the video and not just in the description. It should be at the beginning and in some cases left up. And if you've got a streaming platform like Twitch, you may have to disclose multiple times because obviously somebody may come in the middle and not be there at the beginning. We talked about how even tags can be endorsements. And the FTC has sort of expressly said certain words are not going to work. We talk about nice and naughty words. So saying something like thanks for the clothes is not going to work. You have to say things like free, thanks for the free clothes. Something like just ambassador, that I'm the ambassador for, Sears, is not going to work. But Sears ambassador, hashtag Sears ambassador, identifying the brand is going to work. So I'm going to post in a second a list of sort of nice and naughty words that will distribute the deck here, and that's a handy take home. You also just generally can't mislead as to the nature of the relationship. So you can't say that you got free stuff if you got some free stuff and you got paid. Or you can't say thanks for the trip, which wouldn't work anyway, as we just discussed, if you also got, a check for $1,000. The other thing is that natural language is okay. You can always use, I'm working with Sears. And I don't know why Sears is popping to mind today, but I'm working with Sears, and I think their products are great instead of a hashtag, hashtag Sears ambassador.
And I think that might be relevant to the question that was asked before. Obviously, if a member of your organization is writing, a positive review about the organization, disclosures such as like hashtag ad, it's not applicable there. It doesn't seem relevant. But the member could say, I'm a member of X, Y, and Z, and I think, and that could be a really nice organic way to slot that in there.
Right. Although we do get questions, the FTC has sort of got the fallback of hashtag ad. They seem to think that's really always great. So just 3 little letters and or 3 little characters. That seems to always work. So the FTC has posted this infographic on its website as a little do's and don'ts helpmate. You can see that the letters are, it's a little bit small here, but they do repeat. Ensure your disclosure is hard to miss. Clearly disclose when you have a relationship. Treat sponsored tags, including tags and pictures, like any other endorsement. On image-only platforms, so like Snapchat or the like, superimpose disclosures over the images. That's also true on Instagram. And then don't assume people know about your brand relationships. Don't assume that the disclosures built into the platforms are sufficient. Don't use ambiguous disclosures like thanks, spawn, or ambassador, and don't rely on disclosures that people will only see if they click more. Like I said, the FTC has posted these FAQs on its website. We just talked about Snapchat and Instagram. The FTC on Twitter, it's very important to them that you put the disclosure at the beginning of the tweet or very early on, because if things are retweeted, they could be cut off. So it's pretty practical, but that's something they pay very close attention to. And also a hyperlink or a button that links to a disclosure, according to the FTC, won't work. Here's the nice and naughty list, our take home here. So we've talked about a lot of these, but you'll get that. The FTC continues to bring cases. One of the most recent involved some influencers and sponsorships related to the 2018 Summer Olympics in Brazil. It was a campaign involving both native advertising in the form of news articles posted about a mosquito repellent. You'd think you would need that in Brazil, right? So there were a lot of news articles or advertorials, as we call them, posted about this product. And then athletes were used, like Carly Patterson and Jake Dalton, talking about the product. There were also consumer reviews, which is sort of a hot area, that were posted about the product, all talking about the product without proper disclosure. So the FTC pursued a case against both the company and the owner, because the owner had been posting reviews. So occasionally the commission will pursue cases against individuals as well, which is never great. Certainly not a position you want to be in. Like we've been saying, reviews have been an important area, one that the FTC has been looking closely at, as well as the NAD, the National Advertising Division, which is a self-regulatory group that's active. It's part of the BBB that's active. And, part of the issue is obviously making this material connection disclosure. When you offer somebody something in order to review, whether it's a sweepstakes entry, a gift card, or even, like we said, the opportunity that maybe you will appear on TV talking about the product, your experience. That's all something that needs to be disclosed. In addition, you have a responsibility to make sure that any claims made in the review that you repost or adopt on your website are also substantiated, are true. So that's important. This is the sort of thing where you want to look at making sure that reviews may be tagged, like we talked about Nordstrom, making sure that those tags, things like maybe sponsored, maybe what are good tags? Paid,
Promotion.
promotion.
The rules for advertising, are clearer in my mind than what constitutes advertising. And I'll give you a case. Some years ago, I was with an organization. A former Surgeon General had endorsed completely of his own publishing, but we over several years paid several tens of thousands of dollars in travel for him to go speak about the mission. And typically it was social marketing stuff. It was about child safety. So it was, here's how you keep your kids safe. It clearly endured to the benefit of our fundraising. And we also sold some products, which probably derived from baby terms. But is that kind of relationship something that you would have to disclose?
The question was about the use of, in this case, a Surgeon General had endorsed an organization voluntarily, but then was given free travel and the like as part of the relationship. After leaving office, yes. And so the rules for expert endorsements, can sometimes be a little bit different. In that case, and was this online or was this not online?
Primarily, physical presence, but there would have been online support, right, reinforcing. The former Surgeon General is going to be at X on Y day.
So certainly you need to disclose the relationship and the fact that there is a relationship that involves some compensation in that case and in the modern climate. But like I said, the rules for expert endorsements, there's also making sure that, that you want to make sure that the claims are also, again, substantiated, as we said, and true. But the rules, there are actually some extra rules when it comes to expert endorsements, so you want to make sure that those are being followed. So with regard to reviews then, like we said, there is this, you want to make sure that things are substantiated with reliable data. But then there's also, to the extent that you are posting reviews, reposting reviews, you want to make sure that you're not, and you want to try to aggregate them in any way. You have to be very careful with those, with that aggregation right now, or any claims based on the aggregation, to make sure that you're getting sort of representative claims, and you're not just cherry picking. So that's something that's come up a lot lately, both with the FTC and in the self-regulatory groups, because of the fact that to the extent that you're comparing sort of both incentivized and non-incentivized reviews, that can raise some issues. There's also issues like Amazon is no longer accepting incentivized reviews and the like. There some organizations, when it's nonprofits, are now, of course, licensing products. So this does come up with nonprofits. There are also sorts of issues that are involved with that as well, that I'll let Cindy deal with off the off the clock on this particular clock. But these are why we're discussing these particular issues. There's also a new law the Consumer Review Fairness Act of 2016 that regulates contracts and terms of use, online terms of use, when it comes to reviews, and essentially says that you can't sort of try to suppress negative reviews. So it's something to be careful with when it comes to collecting reviews via your website and trying to essentially sort of say we're going to try to withdraw any incentives for negative reviews. It's very important to try to to allow for both positive and negative reviews, and not do anything that might be perceived as disincentivizing negative reviews.
And on that point, really quickly, the FTC has actually started bringing cases under this new law, the Consumer Review Fairness Act. Those situations have mainly involved cases where there were form contracts where businesses explicitly prohibited people from writing negative reviews, and actually would include clauses such as, if you do this, you owe us damages of X amount of money. That's prohibited under this new law, and so it's worthwhile to take a look back at your terms of use and your form contracts, because even many of our own clients, back in the day, would include just a boilerplate statement saying, you may not write negative reviews about us, but that is now not allowed under this law. So it's worth double checking to take those out.
So we mentioned before that employees must disclose as well. So that idea of, if you're allowing your employees to use social media to talk about your products, you must make sure that's disclosed. Early in the days of social media, there was a lot of discussion of what internal social media policies should say when it came to employees and discussing an organization on social media. There have been a lot of developments, both at the NLRB and what you can and cannot say, how you can and cannot restrict what your employees say about discussing the organization. I'm not going to get into that now, but it's important to be aware of the fact that you're not supposed to be restricting what your employees say. This really talks about what you are sort of supposed to require employees to say when they're sort of promoting the company in any way, which is just, if they are going to go and promote the company, then they should be disclosing, I work at, or not company, but nonprofit, I work at, X organization. I am a, hashtag X organization employee, that sort of thing.
You might have mentioned this already. A like on Facebook by an employee or member, that doesn't turn into that would be disclosure, correct?
For now, the question is about likes on Facebook and whether they are endorsements that require disclosure. For now, the FTC has stayed away from likes on Facebook, primarily because there's really no way to disclose. But, keep an eye on that, both from the perspective of Facebook, which has placed some restrictions from the perspective of how promotions work and what you're allowed to do to incentivize likes, and the someday. But for now, you don't have to do any kind of disclosing when it comes to just liking stuff. So what else do you need to worry about? We mentioned any claims made in advertising must be truthful and substantiated. That applies on social media, offline. Hopefully everybody knows that by now. The important thing is that you may be liable for any claims your influencers make about your product, about your organization. You can't use influencers to say what you cannot say yourself. And if it's wrong, you need to ask the influencer to take it down or correct it. That's true with reviews. That's true with general statements in a campaign. We'll talk about monitoring and enforcement now with a little bit more specificity. But first, we'll talk about Fit Tea and Kim Kardashian. This is actually an example of sort of unsubstantiated and not truthful claims, deceptive claims. There was, I don't know if people have heard of Fit Tea. There's all sorts of claims out there about what Fit Tea can do for your body and mind. It doesn't really work. I know it'll shock you to hear that. But so this picture here is of an influencer. Both of the Kardashians have also gotten involved in promoting it. The NAD, the self-regulatory group I mentioned, investigated the claims in 2017 and found that A, they did not substantiate the weight loss claims, but B, that there were a lot of endorsements and testimonials posted on the website, and then actual product reviews. And so there was sort of a failure to distinguish the real from the fake on the website that was misleading overall and problematic. More recently, Senator Blumenthal wrote a letter to the FTC asking it to investigate the marketing tactics and physical dangers of the product, because there's a lot of sort of interesting and not entirely known ingredients in there that may be dangerous from an FDA perspective. So there's sort of a stay tuned on that, but it's sort of a cautionary tale in terms of making sure that all claims, both yours and third parties, are substantiated when it comes to a product. Also, we've mentioned that any kind of value can be a material connection. A specific example here is sweepstakes entries. As far back as 2014, this is one of the very early closing letters that I mentioned. Cole Haan had run a sweepstakes, or actually a contest, asking contestants to find different images, including Cole Haan shoes, and post them with the hashtag Wandering Soul as a contest entry. The FTC looked at this contest. They ultimately did not decide to bring a case, but they closed the investigation with a closing letter that they used to announce the policy that pins and hashtags and the like the contestants were posting, could in fact be endorsements, regulated under the endorsements and testimonials rule. And because they were incentivized with the offer to win a prize, that there was a material connection that would not be expected by consumers. And so therefore, from then on, sweepstakes or contest entrants would be required to disclose. And essentially that now, under that, what that letter and FTC policy sort of further elucidated in FAQs and the like, when you run a sweepstakes or contest and you're on social media and you're offering a prize, you have to require your entrants or something like that in their entries. And so it actually can make it easier to track the entries through the, through social media. But that is a requirement under this closing letter, under FTC requirements, et cetera. I'm going backwards. I flipped it again. So in terms of general FTC compliance requirements, we've talked a lot about sort of the substance, but what the FTC has essentially said is there's three sort of pieces to a compliance policy when it comes to influencers and influencer policy. First, there's that general policy requirement and the training that you need to give internally and to your agencies and influencers. Then there's monitoring for compliance, and then there's enforcement. So the stool analogy. So first, there's one of the best ways to do this is by entering into an agreement with your influencers regarding compliance. That has sort of two purposes. First, to establish the terms of the relationship, and then that sort of compliance overlay. There's varying approaches as to what the length of that agreement may be. It can be a simple, one page, a couple of paragraphs, but getting sort of sign off from your influencers can ensure compliance. It's often then you incorporate sort of a policy as to what your expectations are about compliance sort of as an exhibit to the agreement. But then the agreement has your expectations as to things like how many posts or tweets, what you may pay or give them, we'll give you a trip or a gift card or whatever. But the important thing is that because the FTC's policy is that you, as the marketer, as the advertiser in this position, are equally responsible, and in fact, in some ways, more responsible in the sense that you're expected to monitor and enforce. It sort of dictates in favor of some sort of agreement, policy, that sort of thing.
And on that point, it's interesting because back when influencer marketing, was just kind of starting out and it was a new form of marketing, a lot of times in these agreements, there'd be maybe one, simple provision saying, and the influencer is responsible for complying with all FTC regulations, and kind of just leave it as a very broad provision without any specifics. Now that, we've seen what the FTC's expectations are through these closing letters, through enforcement actions, and the fact that, really you as the brand, as the company, as the organization also are responsible for compliance. When we're working on influencer agreements, we will oftentimes attach, a pretty detailed appendix that lays out, you must disclose your connection to the brand, and this is how you can do it. Here are some examples, and that's very helpful to the influencers, but it also kind of sets the expectations very clearly between, you as the brand or the organization and your influencers, and making sure that they comply. Yes.
Question on the fourth bullet, please, the second part. It says the brand must contact influencers who violate policy. Would it be reasonable to say, for example, to the influencer, if there were maybe 3,000 people who did click on a hashtag to register or something, that they have to go back and contact each of those because they may not be coming back anymore to the actual
Hello? Okay. So looking at the fourth bullet point, the second portion. So, for example, if an influencer violated a policy or gave a misleading indication, and say 3,000 people have registered through a hashtag, so would it be reasonable for the brand to come back and say, okay, first of all, you have to change the original information, but you have to go back to those 3,000 who have already registered or hit the hashtag to inform them of the misleading information? Would that be reasonable, unreasonable?
Well, that's interesting. There was a case at the NAD, it involved fertilizer, where there was a review involved. It was post a review, and you will be entered to win a gift card. And in that case, there was a challenge by a competitor, and the challenged company went back and they tagged every single entry. Because in that case, they wanted to keep the reviews. And they went and fixed the sort of invite email because the promotion in question was ongoing, so that further, reviews that were posted would be properly tagged. The instruction was not clear enough. In that case, the NAD said, all right, you're good. Our recommendations are let this continue, but we're troubled in general about the use of these reviews when they're incentivized. So in some cases, I think there is a feeling that you should be correcting from enforcement. It'll be situational. Certainly anybody who doesn't post that hashtag will be disqualified from winning the prize in a sweepstakes like that. Okay, so another interesting issue that's come up in California, which we'll explain in a minute, is the issue of whether or making sure that the influencer is an independent contractor. So, in terms of monitoring and enforcement, to delve into that a little bit more, the FTC's position is that the advertiser or the marketer must make sure that the influencer is complying with the endorsements and testimonials rule. That there is this training responsibility, and then if there is a violation, that the brand must go back and correct and instruct. And so the contract itself must have a remedy that's clear. Here's what happens if you violate, and then follow through. And it's important to document. Here I contacted this influence. They violated in this way. I contacted them. We did X, Y, Z. Whether it's there's a warning system, whether it's termination, whether it's a refusal to pay, that sort of thing. Because if you are investigated, then you need to be able to show we had this policy, we followed through, and that's made a big difference in a number of cases between whether or not you get that closing letter or you are required to enter into a settlement. And the difference there is that a settlement generally lasts for 10 to 20 years, imposes specific compliance requirements, restricts your behavior, has reporting requirements. Generally, with a settlement in this area, you won't be required to pay money the first time. It'll just be injunctive and behavior relief. But if you violate it and there's contempt, then there'll be money involved. So it's no fun to operate under an FTC consent decree.
And not to mention the PR damage that it does
Yeah,
as well.
yeah, certainly. In terms of training, there is this expectation that you train internally and with the agencies. Again, it's important to document here, document attendance at the trainings, your people and your people's people. This is something that, if you do conduct e-trainings, it's an area that's very good for e-training. We did a seminar recently with Microsoft, which is like the best at e-training ever. There's no expectation that any of us will reach that level of e-training, but something simpler is certainly achievable. And then leave behind. So things like the do's and don'ts we just did, the naughty and nice words. And this is an area that's very much amenable to combining legal messages with business guidance. Because obviously it's an area where there's a lot of business being done and a lot of practical, consumer protection. There's a lot of practical, a good sense that's being applied here. In terms of monitoring and how much is enough, the FTC really hasn't given specific guidance on how much is enough. Obviously, if you're caught with a failure of disclosures, then it wasn't enough. But if you can show that there's regular monitoring going on, then and it's not once a year, then that's usually good. There should be monitoring being done by you or a third party for effectiveness in any event, and so often that can be combined the sort of monitoring for ROI and the monitoring for legal compliance. So, you can sort of deputize on that front, whether it's you or an agency that's doing it for you, and then set up for regular check-ins and reviews on that. But if you see that problem, then correct it right away. The campaign is over isn't a good answer to the FTC, and then create a paper trail. In terms of enforcement, that clock begins to tick when you're aware of the fact that there wasn't disclosure. So you need to contact the influencer, tell them we saw there was no disclosure, you need to fix it. The fact that it's still floating out there without the disclosure is important, and then you need to impose those consequences that you said you were going to impose for the failure to disclose. And if you continue to work with the influencer who failed the first time, then you need to step up on that monitoring. And again, maintain that paper trail. So in terms of specific things you can put in an influencer agreement in terms of protection, obviously the expectations is in terms of what you want them to do, whether it's 3 tweets and 4 posts and that sort of thing. But you should not be dictating specific content. You can, I've seen certainly things where you dictate, here are things we'd like to see included in terms of facts or that sort of thing, but writing out the script is not a good idea. Then things like representations and warranties about compliance with the endorsements and testimonial guides or other consumer protection rules, privacy rules, that sort of thing, as much guidance as you think they need on that front. We talked about the idea of an influencer policy being more specific. The fact that they are an independent contractor, which we'll talk about in a second in more detail. Arbitration rules are being used more. Indemnification, recognizing that it may be worth exactly the value of the paper it's printed on. With a lot of these influencers, although more and more influencers actually have some worth now, economic worth now. Intellectual property protections, a trademark license if you want them to use your trademarks at all, or if you want to use, again, some of these influencers are very big deals now and may have trademarked something. Also right of publicity and covering for that. Non-compete clauses, restrictions on using competing products for some period of time, and then clear termination provisions. What if the influencer fails to make a disclosure? What will happen? How would you terminate? Would you penalize in some other way? It should be as regimented as possible, but can keep in mind that if something is too extreme, it may be leaked to the internet. This issue of independent contractors. There's a recent case, Dynamex, from the Supreme Court in California, that is quite strict on the issue of who is an independent contractor. I do not profess to be a labor lawyer, so I am qualifying any statement right here and right now and saying I can give you a referral to a very good labor lawyer here, labor employment lawyer. But Dynamex applies this ABC test for when a worker qualifies as an independent contractor. The worker needs to be free from the free from the control and direction of the hirer in connection with the performance of the work, both under the contract for the performance of the work and in fact. B, they must perform the work outside the usual course of the hiring entity's business. And C, must be customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed for the hiring entity. It's something to be aware of, this case, and make sure that you don't end up with an influencer that's an employee rather than an independent contractor. Because to the extent that's the case, you may end up liable for, minimum wages, overtime, statutory penalties, attorney's fees, and tax consequences. We talked about the Fire Festival, this issue of, you don't want to end up sued for the influencer's conduct. You don't want to end up sued by the influencer. You don't want to end up, suing the influencer. The Fire Festival, in that case, we ended up with multiple class action complaints. In some cases, the influencers got sued, although those cases were ultimately dropped. There was all kinds of fraud and misrepresentation. But we're seeing other types of influencer versus brand disputes. Whether it's the influencer botched the claims, Oprah tweeting, "I love my Microsoft Surface" with the tag sent from my iPad. A situation where there's disparagement claims. You're using the competing product. When LeBron James endorsed a product, then tweeted, "My phone just erased everything." False advertising suits, failure to promote sufficiently influencer bad acts. You remember when Disney cut ties with PewDiePie due to his anti-Semitic jokes. The influencer may sue the brand for reputational injuries if there's some sort of recall or for some other reasons, if an event didn't come out as promised that they were associated with. And even just over, we talked about the IP clause in the agreement. If there's some misuse of IP rights on either side. So these are the types of things that you want to try to cover off in a contract, and just proceed with, good sense, and otherwise. There have been a number of suits brought not just by the Federal Trade Commission, but state attorneys general. The New York Attorney General in particular has been active on this issue. Most recently, there was a case involving a company called Devumi Inc. This was just this year, where they brought a case involving the issue of astroturfing, which is the issue of selling fake followers. There's also something called sock puppet accounts. I love that term. But essentially, Devumi was an agency that was using sock puppets and astroturfing to carry out different campaigns, just basically setting up fake accounts to tweet and post and like other different accounts. And so this was the first finding by a law enforcement agency that the sale of fake social media engagement and the use of stolen identities to perpetuate online engagement is illegal. It's sort of a reminder that, some of these agencies are not on the up and up. And so you need to be careful when hiring agencies to sort of do your due diligence, and make sure that, their promises are, some promise that sounds like it is better than anything could possibly be is, may be. So be careful out there. So wrapping up, this is definitely a hot area right now for enforcement and litigation. The fact that we're in, a Republican administration, the FTC is an independent agency, and the Consumer Protection Bureau, which is responsible for enforcement in this area, has continued to enforce, as well as state attorneys general, which of course are picking up the slack in any event where they perceive there might be any any lag in enforcement. And of course, class action attorneys are always interested in a consumer protection suit. It's also, important to think about the fact that this is an area where if you get in trouble, you get in trouble quickly. And so, forget about enforcement, just having a social media campaign go wrong, what I call the red face factor, can be as bad as any investigation or litigation, because of course you're looking for something positive, but you don't want a negative effect in an influencer campaign. So it's just, again, there's a huge amount of common sense here, and you want to watch out for something like Devumi, or even just, something negative, the tide turning in a social media campaign. But it is a situation where the advertiser, the agency, the influencer, all may be liable. And then when you're looking at these campaigns, you need to look at what's being disclosed, how and when you need to disclose it, and also be sensitive to the requirements of the platform itself. These platforms each has rules on its own for disclosures, for sweepstakes and contests, the hashtag sweepstakes plus. So you need to look at those as well. And then, a lot of the time a good agreement can do a lot in terms of protecting you in your relationship with the influencers and making sure that they are compliant. Make sure your employees are compliant, and then follow up with the sweepstakes and the reviews and all that.
I think that concludes our program. So if there are any questions, we'd be happy to take them.
Yes. You may have to turn it on.
That better? Okay. We work for a nonprofit protecting national parks. So since we're not really selling any particular product, or product placement doesn't really apply, just curious if you have any examples of nonprofit promotion that went really well or went really wrong.
I hesitate to dime out any clients, I guess, as I said, one of the issues is also, as we see nonprofits start to get into licensing, that's one issue. But you do see nonprofits who are running a lot of sweepstakes. So certainly that's one issue where making disclosures becomes extremely important, and making sure that the hashtag sweepstakes and hashtag contests are included. You also see the use of influencers in campaigns generally, in that case, in some cases, giving freebies to influencers in order to promote, and keeping in mind that influencers are, even when they receive just smaller freebies, they need to be disclosing that. It's not always sort of kept at top of mind. I'm trying to think sort of one jumping to mind right now, where there was a problem per se, but it's always when you're put on the spot for that it's blanking. Annie, do you have something?
I don't have any specific examples that come to mind. I know, a lot of these guidelines are, or some of them are couched in terms of, commercial advertisements and whatnot. But at the end of the day, the general principle still remains the same, which is that the, FTC's objective and the state AG's objective is that there aren't any advertisements out there that are deceptive and misleading to consumers. So that's always kind of the general principles that you always want to be mindful of when you're engaging with an influencer or putting out any kind of material to consumers. I can't think of an example off the top of my head where it involved specifically a nonprofit that was doing native advertising or influencer marketing campaigns.
Would an example be if you invite a celebrity to join like your charity dinner and gave them a table for free to get their endorsement of your?
That could certainly be an example. Also, commercial co-ventures, where you are sort of hiring people in order to promote. You certainly see a lot more usage, just because there's more money backing, of influencers in those campaigns. And in that case, either payment or offering of free goodies for participation. I'm trying to think of additional situations. Even just free entries into dinners, into events, may need to be disclosed to the extent that the individuals are then being incentivized. Come to this event for free, promote it, if that's an affirmative obligation. So those are all things to consider.
I have one more question for the affirmative obligation. So if in example, you invite the celebrity and you give them a table at your dinner with the hope that they're going to do an Instagram story about the event, if it's an affirmative obligation, it could remain unstated and that would be okay for us? Or if the implied expectation is social media content would follow, does that require disclosure?
In that, if it's implied obligation hopes, that's probably not going to, in that case. Now, if it's something where you have an ongoing relationship, that's a tougher thing. One of the issues that's come up periodically is, OG, we have a 1-year contract with X, and we do have they're contracted to tweet 4 times, but then they tweet 10 times more. Are they supposed to disclose in those additional tweets? In that case, the FTC's position is yes. There's all sorts of twists and turns on these.
Any other questions?